Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about something pretty important to a lot of people, and I've been given this question a lot. So let's go into it. It has to do with picking your judge. Many foreclosure cases where the homeowner is the plaintiff suing the bank end up in federal court. And so federal court is where you pick your judge. So this presentation is about picking your judge in federal court, magistrate judge versus district judge. So let's look at this. Choosing your judge in federal court. When a foreclosure case is filed in federal court, you may be asked to decide, do you consent to a magistrate judge or keep the district judge? Most pro se litigants check a box without really understanding the consequences. Today we will cover what a magistrate judge is, what a district judge is, the pros and cons of each, strategic considerations, the consent form that you must file. Federal court structure. Federal civil cases normally involve two types of judges. The district judge is an Article III judge, is appointed for life, has final authority over the case. And then you have your magistrate judge, is appointed for an 8-year term, assists district judges, can run the entire case if both parties consent. Without consent, magistrates handle limited matters only. What a magistrate judge normally does, without consent, a magistrate judge may handle scheduling conferences, discovery disputes, settlement conferences, pretrial management, and reports and recommendations on motions. However, the district judge still makes the final decision on dispositive motions. Examples: a motion to dismiss, a motion for summary judgment, or a trial. What happens if you consent? If both sides consent, the magistrate judge becomes the trial judge. The magistrate judge can then decide on motions to dismiss, rule on a summary judgment, conduct the trial, and enter the final judgment. Appeals go directly to the Circuit Court of Appeals. The district judge is removed from the case. Why some lawyers prefer magistrate judges. And we're talking about the other side, the banks. Some attorneys prefer magistrate judges because cases move faster, judges often have lighter dockets, more time is spent on each case, often more hands-on with discovery, and magistrate judges often encourage settlement or mediation early. Why some defendants prefer district judges. In foreclosure defense cases, many defendants prefer keeping the district judge because district judges are Article III judges. They have lifetime appointment, their rulings carry greater weight, and they are sometimes more cautious on the summary judgment. This can matter when standing is disputed, chain of title is questionable, discovery disputes are critical. So for strategic considerations, choosing your judge depends on your strategy. Magistrate judge may be helpful if you want faster case movement, discovery disputes are central, you want a judge deeply involved in the case. However, district judges may be better if the case involves complex legal issues, you expect major dispositive motions, you want maximum procedural protection. So an important rule: consent must be voluntary. No judge or opposing attorney can force you to consent. If one party does not consent, the case remains with the district judge. Your decision cannot legally be used against you. The consent form. Federal courts typically send a form called Notice of Availability of a United States Magistrate Judge. You must indicate, yes, I consent, or no, I do not consent. Then file the form with the clerk. Some courts require all parties to file separately. The key takeaways: before choosing your judge, ask, how complex is my case? Will discovery disputes matter? Do I expect summary judgment battles? Do I want speed or procedural caution? This decision can shape the entire case. Never check the box without understanding your strategy. Many pro se litigants report that magistrate judges sometimes apply procedural rules very strictly when reviewing complaints. This can especially show up on Rule 12b-6 motion to dismiss. Why this sometimes happens. Magistrates handle a high volume of early stage motions. Magistrate judges frequently deal with motions to dismiss, discovery disputes, and case management. Because of this, they often focus heavily on procedural sufficiency of the complaint. Number 2, reports and recommendations create a filtering role. When parties do not consent, a magistrate judge typically issues a report and recommendation, or an R&R. Federal Rules of Civil Procedure, Rule 12b-6, allow dismissal if a complaint fails to state a claim. The magistrate judge's R&R is then reviewed by the district judge. Some magistrates see their role as screening weak complaints early, especially in pro se cases. Number 3, district judges sometimes take a broader view. District judges often review the entire litigation context, consider whether amendment is possible, apply a slightly more flexible reading of pro se pleadings. Federal law requires courts to construe pro se filings liberally, but how that principle is applied can vary. Why banks sometimes prefer magistrate judges in foreclosure litigation. In some foreclosure cases, lenders and servicers may prefer magistrate judges because magistrates often manage cases more aggressively and efficiently. This can benefit institutional litigants who handle large volumes of cases. Common reasons include faster case movement. Magistrate judges often have more availability on their calendars. This can lead to faster scheduling orders, shorter discovery timelines, earlier hearings on motions. For banks that are seeking a quick resolution, faster case movement can be advantageous. Number 2, early screening of complaints. Magistrate judges frequently handle motions to dismiss, preliminary case management. Because of this, they sometimes focus closely on whether the complaint meets pleading standards under the Federal Rule of Civil Procedure, Rule 12b-6. Large financial institutions often prefer early resolution of cases before extensive discovery occurs, as we know. Heavily emphasis on procedure. Number 3, magistrate judges are often very focused on proper pleading standards, compliance with procedural rules, and timely filings. Institutional litigants with experienced counsel are typically very comfortable navigating procedural requirements, which can work to their advantage. Number 4, encouragement of settlement. Magistrate judges frequently conduct settlement conferences, mediation discussions. Banks sometimes favor these processes because they can resolve disputes earlier and reduce litigation costs. Strategic insight for homeowners. Understanding this dynamic can help pro se litigants think carefully about the magistrate consent decision. Before consenting, consider the complexity of your claims, whether discovery will be important, whether you expect significant motion practice. Choosing whether to consent to a magistrate judge can shape and pace the structure of the entire case. That little magistrate consent form can quietly determine who controls the pace of your case and how quickly key motions are decided. The hidden risk of consenting to a magistrate judge. When you consent to a magistrate judge, the magistrate becomes the trial judge for the entire case. This means that the magistrate judge can rule on motions to dismiss, decide summary judgment, conduct the trial, enter final judgment. There is no review by the district judge. What happens if you do not consent? If you do not consent, the magistrate judge usually issues a report and recommendation on major motions, for example, motions to dismiss or motions for summary judgment. These recommendations are often reviewed by the district judge. Why that extra layer matters. If you disagree with a magistrate recommendation, you can file written objections under Federal Rule of Civil Procedure 72. The district judge must review those objections. This creates an additional opportunity to challenge the ruling before judgment is entered. What happens if you consent? If you consent, the magistrate judge reviews the final ruling. There is no district judge review. Your appeal is sent to the U.S. Court of Appeals. Appeals are harder and more expensive. So strategic consideration for pro se litigants are this. Without consent, a magistrate, it goes to recommendation and district judge review. With consent, magistrate goes to the final judgment and then to appeals court. That extra step can sometimes make a huge difference in these cases. How to research your federal judge. Before making strategic decisions in your case, it helps to understand your judge's background and prior rulings. In just a few minutes, you can learn the judge's professional background, prior career experience, how they typically handle motions to dismiss, whether they have handled foreclosure or banking cases. This information can help you better understand the court's expectations and tendencies. So step 1, read the judge's official biography. Start with the judge's biography on the court's website. You can usually find education, prior law firms, government positions, prior judicial experience. Example, the United States Courts provides official profiles for federal judges through the district court websites. And things to notice: former banking or corporate defense attorney, former prosecutor or other government lawyer, prior consumer protection work. These backgrounds sometimes influence how judges approach certain issues. Step 2, search prior rulings. Search the judge's name along with key phrases like motions to dismiss, foreclosure, FDCPA, standing, and you can also use these other search engines like Google Scholar, Court Listener, and Pacer. Court Listener provides free access to many federal court opinions. This allows you to see how the judge has ruled in similar cases. Step 3, look at the judge's standing orders. Most federal judges publish standing orders. These documents explain motion practice requirements, discovery expectations, formatting rules, pretrial procedures. Many procedural mistakes by pro se litigants happen because standing orders were not reviewed. Step 4, review recent cases. Look at recent cases assigned to the judges involving mortgage servicers, banks, consumer protection statutes. This helps you see how motions are analyzed, how the judge treats pro se pleadings, whether cases are dismissed early or allowed to proceed. And here's a practical tip. Before filing major motions, always ask, how does my judge usually analyze this issue? Understanding your judge's approach can help you structure arguments more effectively, anticipate questions, avoid common mistakes. And the most powerful thing you can do before filing anything in federal court is to spend 15 minutes studying your judge. Now let's look at what a notice of non-consent to a magistrate judge looks like. This is Lori Nielsen's case out of Utah, and she is suing HUD and CompuLink for a reverse mortgage. Now, she decided the best thing for her is to not consent to a magistrate judge. Her case is complex and involves government entities, so a magistrate judge would not be a good decision for her. So basically it states here, now comes plaintiff Lori Nielsen respectfully notifies the court that she does not consent to the jurisdiction of a United States magistrate judge for all proceedings in this matter pursuant to 28 U.S.C. 636C. Plaintiff requests that this case remain assigned to the district judge for all dispositive matters. Respectfully submitted. And then she has a certificate of service to serve the other side as well. Anyway, that's how that works. That's as simple as easy to get. Sometimes those court forms are really annoying to even try to fill out. So just filing something as simple as this is all you need to do. The next thing we're going to look at is judges. We're going to use Carrington's case as an example. He's in the New York Eastern District. And you can see in his case, Eric R. Committee is the presiding judge, with Clay H. Kaminsky is the magistrate judge. The last thing was filed was July 24, 2025, and they still have a pending motion to dismiss, which is taking forever for the judge to decide. So let's look at what the judges, this is one of the judges, and you can see there is a biography on this judge right here. And then if you go, you can also see this section here that says judges. You just click on judges, and then you have a choice of choosing magistrate or district judges. Click on district judges. His district judge is in here. Show more. Well, come on. Here you see his judge here, and then here's his biography. Interesting that he has experience. It says previously served as a general counsel for Viking Global Investors LP and a member of its management committee. Not in that capacity, he oversaw legal compliance and regulatory matters for the firm. And then it says also he was assistant U.S. attorney in the Eastern District of New York, serving ultimately as chief of the business and securities fraud section. So he has some securities fraud experience, considering that Carrington's case involves RICO actions. That ought to be interesting to see how he rules on his case, huh? Okay, so one more thing we want to look at, and that's this. If you have this AI program, Sentient, I put in here as a search, I said, the federal judge out of New York, Eric R. Committee, can you look and see if there are any federal cases where he ruled on a pro se complaint against a mortgage servicer or a bank? And this is what it came up with. And it came up with some cases, and you can actually click on the actual cases. And you know, this might be helpful, you know, when you're researching your situation. And so just so you can see here, this case is relevant because it involves a pro se debtor who filed a complaint against a mortgage company, Nation Star. While the judge is not Eric R. Committee, the case addresses similar issues and could provide insights into how courts handle such disputes. Specifically, the court addresses whether attorney's fees can be charged to the debtor, and states, based on its review of debtor state court complaint and the summary judgment order, the court finds that the debtor's state court action was legal proceeding that might significantly affect the lender's interest and rights because the debtor sought a declaratory judgment from the state court that the note and mortgage were invalid and unenforceable. And then you can also see that there's another one here, Young versus J.P. Morgan Chase. This document is relevant. It's a decision by Judge Eric Committee in the Eastern District of New York regarding a pro se plaintiff bringing a case against J.P. Morgan Chase about alleged fraudulent mortgage practices. The court opinion states plaintiff Ethel Young brings this action against defendant J.P. Morgan Chase alleging fraudulent mortgage practices. So it does make sense to do your homework, guys. It'll help your case survive dismissal. And as we all need to do, is we need to do everything we can to win against these banks. I hope this information has been helpful. And if you have questions, you can always send me an email to foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.